Hi everyone, my name is Sinead M. Capapas, a BS Accountancy student from the University of San Carlos. And as a final requirement in our subject AC2103, I am tasked to discuss 25 sections from the Revised Corporation Code of the Philippines or the Republic Act 11232. So let's start.
Section 19. De facto corporations. The due incorporation of any corporation claiming in good faith to be a corporation under this code and its right to exercise corporate powers shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding.
In this section, it talks about the legalities of de facto corporation. But first, let's define de facto corporations. Basically, these are corporations that are legally recognized but are not in accordance with the law or did not comply with all the requirements needed. Now, in this section, they are protected by the law. And when I say protect, it means that they cannot be questioned in every transaction or every party they enter into, except the Solicitor General in a quo warranto proceeding. But who is the Solicitor General? And what is a quo warranto proceeding? Well, a Solicitor General is a person who represents the people of the Philippines, the Philippine government, its agencies, instrumentalities, officials, and agents in any litigation, proceeding, or investigation before the Supreme Court and the Court of Appeals. Now, if you know this person, Jose Caleda, then you know who is our Solicitor General. While a quo warranto proceeding is a special form of legal action used to test in an artificial or a natural person's legal rights. Now that's for Section 19.
Section 20. Corporation by estoppel. All persons who assume to act as a corporation knowing it to be without authority to do so shall be liable as general partners for all debts, liabilities, and damages incurred or arising as a result thereof, provided, however, that when any such ostensible corporation is sued on any transaction entered by it as a corporation or any tort committed by it as such, it shall not be allowed to use its lack of corporate personality as a defense. Anyone who assumes an obligation to an ostensible corporation as such cannot resist performance thereof on the ground that there was in fact no corporation.
Corporation by estoppel are so-called corporations who pretend to be acting under a corporate license. Now, this section is not created to protect such corporations, but to protect third persons who acted in good faith because of the previous conducts, acts, and representations they relied upon. Now, for example, A, B, and C introduced themselves to D as incorporators of ABC Company. Now, D sued them for not paying $1 million debt to his company. Now, as a defense, they said that there is no corporation, therefore no corporate liability. The question is, can they use this as a defense? No, because of corporation by estoppel or an ostensible corporation. Meaning, A, B, and C are liable as general partners to their debt to D. So that's for Section 20.
Section 48. Kinds of meetings. Meetings of directors, trustees, stockholders, or members may be regular or special.
In this section, it is simple and self-explanatory that there are two kinds of meetings. We have regular and special. Now, these are discussed specifically in the next section, but I will give a brief discussion about their differences, which is very simple. So, regular meetings are done regularly from the word itself, regular. So, it is held on a routine basis. While special meetings are held to discuss about the urgent issues of the company. So for example, ABC Company have regular meetings on the third week of the first month of every quarter. Now on the first week of July, a fire broke out on one of their factories. So the chairman of the board called for a special meeting a week after the fire. So that's an example of a special meeting. So that's for Section 48 kinds of meetings.
Section 69, Court Action to Recover Unpaid Subscription. Nothing in this code shall prevent the corporation from collecting through court action the amount due on any unpaid subscription with accrued interest, cost, and expenses.
There are instances that a company issues subscriptions. These are shares that an investor or a subscriber promised to buy. Subscribed share capital is the total monetary value of all the shares a subscriber promised to buy or have an interest upon. Now, for example, ABC Company issued 10,000 shares of stocks to D, a subscriber, with a total amount of 1 million peso, payable every month within 10 months. Now, D, the subscriber, failed to pay his subscription on the 4th month until the 10th month. So, the ABC Company can appeal to court in order to recover the unpaid subscription of D together with accrued interest, costs, and expenses.
Section 70, Effect of Delinquency. No delinquent stock shall be voted for, be entitled to vote, or be represented at any stockholders' meeting, nor shall the holder thereof be entitled to any of the rights of a stockholder except the right to dividends in accordance with the provisions of this code, until and unless payment is made by the holder of such delinquent stock for the amount due on the subscription with accrued interest and the costs and expenses of advertisement, if any.
This section is connected to the earlier section. Delinquent stocks are stocks that the holder or the subscriber failed to pay, therefore shall not be voted for, be entitled to vote, be represented at any stockholders' meetings, nor shall have the rights of a stockholder except the right to dividends until the amount due is paid with the accrued interest, costs, and expenses.
Section 71, Rights of Unpaid Shares. Non-delinquent. Holders of subscribed shares not fully paid, which are not delinquent, shall have all the rights of a stockholder.
Holders of non-delinquent, not fully paid subscriptions have all the rights of a stockholder. When I say non-delinquent, not fully paid subscriptions, it means that these are subscriptions that are not fully paid but are regularly paid by the holder.
Section 89, Non-transferability of membership. Membership in a non-stock corporation and all rights arising therefrom are personal and non-transferable, unless the articles of incorporation or the bylaws otherwise provide.
Here it is already self-explanatory that members of a non-stock corporation cannot transfer their membership unless otherwise provided by the articles of incorporation and the corporate bylaws.
Section 90, Termination of membership. Membership shall be terminated in the manner and for the causes provided in the articles of incorporation or the bylaws. Termination of membership shall extinguish all rights of a member in the corporation or in its property unless otherwise provided in the articles of incorporation or the bylaws.
In the previous section, it talks about the transfership or the transfer of membership of a non-stock corporation. Here in this section, it talks about the termination of membership in a non-stock corporation. Now, in doing so, it must be in a manner and for the causes provided in the Articles of Incorporation and Corporate Bylaws. Termination means that their rights to the company's properties are all terminated also, unless otherwise provided again by the Articles of Incorporation and Corporate Bylaws.
Section 92. List of members and proxies. Place of meetings. The corporation shall, at all times, keep a list of its members and their proxies in the form the Commission may require. The list shall be updated to reflect the members and proxies of record 20 days prior to any scheduled election. The bylaws may provide that the members of a non-stock corporation may hold their regular or special meetings at any place, even outside the place where the principal office of the corporation is located, provided that proper notice is sent to all members indicating the date, time, and place of the meeting, provided further that the place of meeting shall be within Philippine territory.
List of updated members and proxies are needed before 20 days before a scheduled election. Now, proxies are needed as they are the representative of members who cannot attend. Now, as for regular and special meetings, they can be held anywhere as long as a notice is sent to all the members and within the Philippine territory only.
Section 107. Classes of religious corporations. Religious corporations may be incorporated by one or more persons. Such corporations may be classified into corporations sole and religious societies. Religious corporations shall be governed by this chapter and by the general provisions on non-stock corporations insofar as applicable.
Religious corporations can be incorporated by one or more persons. If one, called as corporation sole; if more than one, then called as religious societies. These religious corporations are governed by the provisions of a non-stock corporations insofar as applicable.
Section 108. Corporation sole. For the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church, a corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of such religious denomination, sect, or church.
Corporation sole is from the word itself. Sole is incorporated by one person only. As mentioned in the previous section, it is a classification of a religious corporation. Now, it can be formed by any presiding elder of a religious denomination, an example of which is Iglesia ni Cristo.
Section 115. Applicability of provisions to one-person corporations. The provisions of this title shall primarily apply to one-person corporations. Other provisions of this code apply suppletorily except as otherwise provided in this code.
It is stated here that the provisions of this title, Chapter 3, One-Person Corporations, is primarily applied to one-person corporations. So basically, from this section, Section 115 to Section 132. It is also stated here that the other provisions of this code, Revised Corporation Code of the Philippines, is applicable or supplementary applicable to one-person corporations unless otherwise stated.
Section 116. One-person corporation. A one-person corporation is a corporation with a single stockholder, provided that only a natural person, trust, or an estate may form. Section 116. One-person corporation. A one-person corporation is a corporation with a single stockholder, provided that only a natural person, trust, or an estate may form a one-person corporation. banks and quasi-banks, pre-need, trust, insurance, public and publicly listed companies, and non-chartered government-owned and controlled corporations may not incorporate as one-person corporations, provided further that another persons who is licensed to exercise a profession may not organize as a one-person corporation for the purpose of exercising such profession except as otherwise provided under special laws.
A one-person corporation is defined in this section, and according to its definition, it is a corporation that have only a one stockholder. So this stockholder can only be a natural person, an estate, or a trust. An example of which is Smart Transportation and Solutions (OPC), which is owned by a one single person, stockholder named Arnolfo Divina. It is also added here that a person cannot organize such corporation if his purpose is to practice or exercise his own profession. Now for example, A is an accountant. So he cannot build up an accounting firm under one person corporation because his purpose is to practice accounting, which is his profession.
Section 117. Minimum capital stock required for one-person corporation. A one-person corporation shall not be required to have a minimum authorized capital stock except as otherwise provided by special law.
Because a one-person corporation is only owned by a one stockholder, then he cannot issue capital stocks because it can multiply the stockholders unless otherwise provided by special law.
Section 118. Articles of Incorporation. A one-person corporation shall file articles of incorporation in accordance with the requirements under Section 14 of this code. It shall likewise substantially contain the following. A. If the single stockholder is a trust or an estate, the name, nationality, and the residence of the trustee, administrator, executor, guardian, conservator, custodian, or other person exercising fiduciary duties together with a proof of such authority to act on behalf of the trust or estate, and B. Name, nationality, residence of the nominee and alternate nominee, and the extent, coverage, and limitation of the authority.
A one-person corporation is also required to have articles of incorporation in accordance to the requirements of Section 14 of this code. Aside from those shown, it shall also contain the following. If the single stockholder is a trust or an estate, it must contain the name, nationality, and residence of the person exercising fiduciary duties, together with a proof of such authority on behalf of the trust or estate he belonged to. Also, it must contain the name, nationality, and residence of the nominee and alternate nominee, and the extent, coverage, and limitation of his authority.
Section 119. Bylaws. The one-person corporation is not required to submit and file corporate bylaws.
This section is very simple and very self-explanatory that a one-person corporation is not required to have corporate bylaws.
Section 120. Display of corporate name. A one-person corporation shall indicate the letters OPC either below or at the end of its corporate name.
If you have remembered my example of a one-person corporation earlier, then you must have observed or remembered that it has OPC initials at the end of its corporate name. Now, if you haven't remembered, I'll say it again. Smart Transportation and Solutions, OPC.
Section 121. Single stockholder as director, president. The single stockholder shall be the sole director and president of the one-person corporation.
Because a one-person corporation is only owned by a one stockholder, therefore, you shall also be the sole president and director of such corporation. Because who will it be if it only have a one stockholder?
Section 133. Methods of dissolution. A corporation formed or organized under the provisions of this code may be dissolved voluntarily or involuntarily.
These methods of dissolutions are applicable to all kinds of corporations. So it can be voluntary or involuntary. So voluntary, it is when it is decided by the stockholders themselves. For involuntary, so for example, ABC company did not comply with the jurisdictions of the court or did not or failed to pay taxes, for example. So they can be dissolved by the court or through the law.
Section 140. Definition and rights of foreign corporations. For purposes of this code, a foreign corporation is one formed, organized, or existing under laws other than those of the Philippines, and whose laws allow Filipino citizens and corporations to do business in its own country or state. It shall have the right to transact business in the Philippines after obtaining a license for that purpose in accordance with this code and a certificate of authority from the appropriate government agency.
In short, foreign corporations are corporations that conduct business here in the Philippines but are incorporated outside the country. Now, these corporations can only transact business here in our country if they have already obtained a license and certificate of authority to transact. Now, we have popular brands or popular corporations here in popular foreign corporations here in our country. That's Coca-Cola FEMSA, Nestle, Pepsi-Cola, and others. Now, these are household names in the Philippines, but they originally not from the Philippines.
Section 173. Outstanding capital stock defined. The term outstanding capital stock, as used in this code, shall mean the total shares of stock issued under binding subscription contracts to subscribers or stockholders, whether fully or partially paid, except treasury shares.
In short, outstanding capital stock is these shares of stocks that are in public hands, whether it is fully paid or partially paid. It excludes treasury shares as treasury shares are subsequently repurchased by the company, meaning they are not in public hands.
Section 174. Designation of governing boards. The provisions of specific provisions of this code to the contrary notwithstanding, non-stock or special corporations may, through their articles of incorporation or their bylaws, designate their governing boards by any name other than as Board of Trustees.
Non-stock or special corporations may name their governing board aside from Board of Trustees. So they can name it governing body or executive board or administrative board or whatever they want through their articles of incorporation or corporate bylaws.
Section 185. Applicability to existing corporation. A corporation lawfully existing and doing business in the Philippines affected by the new requirements of this code shall be given a period of not more than 2 years from the effectivity of this act within which to comply.
Corporations that are formed before this code are given 2 years to comply, starting from its effectivity. So, it is effective on February 23, 2019, 2 days after President Duterte signed it into law. So, the 2 years given would end on the same day next year, 2021.
Section 186. Separability Clause. If any provision of this Act is declared invalid or unconstitutional, other provisions hereof which are not affected thereby shall continue to be in full force and effect.
This section means that if one of the provisions of this code is unconstitutional, the provisions that are not connected to it will continue to be effective.
Section 187, Repealing Clause. Batas Pangbansa bilang 68, otherwise known as the Corporation Code of the Philippines, is hereby repealed. Any law, presidential decree or issuance, executive order, letter of instruction, administrative order, rule or regulation contrary to or inconsistent with any provision of this Act is hereby repealed or modified accordingly.
The provisions provided in the old corporation law of the Philippines is now ineffective. So all the provisions that are contrary to this new law, new corporation code is now Section 187 of this code is actually my 25th section, but I'm gonna be discussing one last section, and that is the last section of the Revised Corporation Code of the Philippines.
Section 188, Effectivity. This Act shall take effect upon completion of its publication in the Official Gazette or in at least 2 newspapers of general circulation.
So it is provided here that this code will be officially effective upon the publication of the Official Gazette or of at least 2 newspapers of general circulation, such as the Philippine Inquirer, the Philippine Star, the Manila Bulletin, and others. So that's all. Thank you for listening and thank you for watching, and please pray for my grade that I will pass this sem. Merry Christmas and Happy New Year!